Now moving on to our second question for the day for you. As you said, this is from an agent, and what they want to do is they want to confirm what documents they need in this particular circumstance. So they've received a managed mandate for residential property, but the property in this circumstance is owned by minors, a 3 and a 6-year-old. And the father of the two children has now signed the mandate for the agent. What the agent wants to know is, do they need a power of attorney from the attorneys in order for the dad to sign the mandate on behalf of the children?
So the first observation I'd like to make when it comes to the appointment of a letting agent is that the mandate is crucial. It's one of the most important documents, and you as an agent rely on it quite intensively when it comes to claiming your commission and understanding the nature of your duties and the scope of your duties. So having that mandate completed is an imperative. And we're noticing more and more a move towards ensuring that these mandates are complete. Unfortunately, not all completion and signature of mandates are as simple as we'd like. And in an instance where a property is owned by minors, in this instance, a 3 and 6-year-old, the property is owned by those minors, but those minors do not yet have the legal capacity to be able to deal with that property without the assistance of an adult. And this is normally where parents step into play and assist these minors in ensuring that their best interests are taken care of. Now, just a note, there's a very big difference between letting out a property and selling a property. And as agents, please distinguish that. Simply because you may have received a mandate from the parent of a 3 and 6-year-old to let a property does not mean that in that mandate, where it may mention, for example, the authority for you to attempt to sell the property and claim commission, that does not actually give you the right to do so, because the sale of a property that belongs to a minor is very different to the letting of a property. And with the sale of a property, one would need to approach the High Court for consent, whereas with the letting of a property, one would not need to approach the High Court, and all an agent would need is a mandate that's signed by the guardian or guardians. Now, I say guardians because if it's only signed by the father, and the mother is a guardian, and she is around and she is available to sign the mandate, she should sign the mandate. Both guardians need to make this decision. Why? Because it is still encumbering the property, in the sense that now you're placing tenants on the property that have the right to occupation. So the children are actually disposing of a right temporarily, but they're disposing of their right to occupy the property. And because this is a disposal, and because it's something that they're losing, it is important that at least the right steps be followed. So both parents or both guardians, if both guardians are available, they need to sign this mandate. In that instance, no one needs a power of attorney, because the children can't give a power of attorney to their parents. That's not how it works. The guardians, by virtue of our law, already have the authority to act on behalf of the children. So there's no power of attorney to that extent. The power of attorney where usually if a third party wants to rent out a property and they appoint someone locally to give authority to an agent, that's different because they don't have that father-child relationship. But the father-child relationship authorizes or entitles the guardian in order to be able to act on behalf of the children. So a power of attorney in this instance will not be required. The father and or mother will be able to sign this mandate, give the agent authority to procure a tenant and to manage the property without any issue at all.
Perfect. Thanks, Bruno. And that brings us to the end of today's session. Thank you very much, and we'll see you next week.
Cool. Thanks, Nick.
Thanks.